conviction pursuant to a negotiated plea. Mr. House is asking the court to reverse that and grant him relief because of
Are you going to reserve any time?
I'm sorry, Your Honor, yes. 5 minutes, if I may,
Okay.
please. Thank you. That's what happens when I don't write that at the top of my sheet to remind myself. Mr. House was denied the opportunity to defend himself at the very beginning stages of his trial. And the deprivation amounted to a denial of due process because the state was allowed to seal the probable cause affidavit that justified the search of his home. The state agreed that all of the evidence against Mr. House came from the fruits of that search. And so the search would have been dispositive had he been able to.
So what's the state supposed to do if there's an ongoing investigation with a CI that they need to protect so they still have access to it?
That's actually developed at great length, Your Honor, in both in rules and in case law. The state can seek to protect specific information within a probable cause affidavit, and that was never at issue below. The problem was that the state here took the position that the entire affidavit had to be sealed, and then where things really took a detour away from due process was when the trial court, in response to the defense challenge to that, didn't even look at the affidavit, but simply left it sealed, said, no, I'm leaving it the way it is. Your motion to unseal it is denied. And so we have no record of what was actually in the affidavit.
Counsel, let's say I agree with you that the trial court erred in not unsealing the documents, or just not having an in-camera review, not doing what the trial court should have done in this case. Isn't there a remedy to that other than going straight to, well, we're just going to suppress the evidence? And shouldn't they have undertaken that remedy before trying to get the evidence suppressed?
I'm not sure what other remedy there would be.
Like, say, an extraordinary writ to this court.
If you look at the record, Your Honor, and that could happen in theory. I think it would be akin to the procedure that you follow when you lose an immunity hearing and you seek a writ so that the court can't go further in the prosecution.
So it seemed, go ahead.
I'm sorry, Your Honor. What happened here, if you look at the record, was that the motion to unseal the affidavit was denied, and the court pressed on. The court put pressure directly on the litigants, on the defense, saying, file your motion. This case is moving ahead. And so I don't think you can fault the defense in this case for attempting to have that evidence suppressed when that is what the trial court directed it to do.
Well, it sort of created a difficulty when they do file the motion to suppress instead of trying to challenge the unsealing, because as the state's pointed out, you have the burden of establishing something at a suppression. This was a warrant case, so the burden is going to be on the defendant. Of course, you can't meet that burden because you haven't had it unsealed.
Exactly.
But the answer to that seems to me to simply challenge the unsealing before you just move straight to, well, we're just going to suppress the evidence.
And again, I think Your Honor has a point. That would have been a possible course of events. It's not what happened in this record. And furthermore, that I would add that, yes, the defense has a burden in a warrant case of challenging probable cause. But before we got to that burden, the state had a burden to justify the sealing of the affidavit, and the state was never held to that burden. So you have a situation where the court was pressing on. The court instructed the defense, file your motion to suppress. This case is moving forward. The court then informed the defendant specifically, both when denying the motion to suppress and then repeating again at the plea hearing, your issues are wrapped up together and they're both preserved. And I think in that situation, you can't penalize the defense for the course of action that it took.
How do we get to the affidavit in support of the search warrant here, though? Even if we find that conceivably that was error by the trial court in not conducting an in-camera review, as the Rule 3.220 pretty clearly to me seems to require.
Yes,
but even if we say, well, they should have done an in-camera review, there was a plea, and what's on appeal is the motion to suppress, and the motion to suppress is basically just a hollow motion. It doesn't can't raise any grounds because there was nothing in the, in the affidavit, or they didn't have the affidavit to challenge. Even if we find that there's a problem by what the trial court did, how does that help your client with any relief, given that there was a plea?
Because the motion to suppress was not denied, it was stricken. And so what was reserved was the issue of the defendant being prevented from litigating the existence or non-existence of probable cause before he went ahead with his plea.
That a motion to suppress that doesn't raise any grounds probably should be stricken, though, right?
But in this case, the defendant was in a catch-22 that the state created by taking this blanket approach to sealing the probable cause affidavit.
But I just go back to what I said before. The reason they were in a catch-22 is that they chose as the remedy to the court's refusal to unseal the records to simply file a suppression motion instead of trying to challenge the unsealing. So the suppression motion was, as Judge Bilbrey pointed out, it was hollow, and it was certainly hollow for good reason. But it seems like it's based on the fact that they refused to unseal, which was challengeable.
It was challengeable. In hindsight, you can say that maybe there was another remedy that the defense should have tried. I would respectfully disagree that the defense put itself in this position. The defense was put in this position by first
They
by
were
the
forced
state,
to file a motion to suppress?
by the court instructing them, this case is moving ahead, file your motion. Yes, Your Honor. In that situation, the defense responded to the court that was in front of it and took the course of action that the court was instructing it to follow. The problem was that the state took this blanket approach to the probable cause warrant, which is not justified under any construction of the discovery rules or case law. You have certainly well-developed case law that when the identity of a confidential informant is at risk, that can be redacted or sealed and the remainder of the information disclosed. And here the state simply said, the warrant is sealed, or the probable cause affidavit attached to the warrant is sealed. And when it came time to review that, the judge didn't even look at it. The judge just kept it sealed.
Well,
There's
and
no evidence.
apparently the ASA didn't even look at it either. They were
Correct.
relying on law enforcement, which is
Correct.
troubling.
They simply relied on the original, whatever original assertion caused the original signing judge to seal the warrant, and we don't even know what that is. And that's one of the main problems, one of the serious problems with the situation we're in now is that there's nothing for this court to review in terms of findings or justification.
Because it was sealed not with the court, but with the sheriff's office.
Well,
There's no affidavit anywhere in the Escambia Clerk of Court records, correct?
That's what the record indicates. There was a point, I believe it was at the motion to suppress hearing, where the assistant state attorney represented that an officer was there with the sealed warrant that could be inspected if the trial court chose to, and the trial court didn't. The trial court
And there's a
simply
case that
kept it
his
sealed.
name escapes me, but from back in the 80s where we were in kind of a similar situation, but a sealed warrant was in the file. The DCA looked at that warrant and said, oh, you got nothing there, and said it was harmless error then. But we don't have the ability to find any harmless error here, correct?
That's correct. This court's review is hampered by the lack of findings and by the way that the procedure transpired below. So what should have happened was, and again, Your Honor, I take your point about there being another possible remedy for this situation. But what should have happened at a minimum was at that motion to suppress hearing, the trial judge should have taken the opportunity to view that sealed warrant, make it part of the court file, and to make whatever findings were necessary to justify keeping it sealed. We know from the argument that the assistant state attorney made that there may have been a confidential informant involved. We don't know any more than that. And of course, what she says is not evidence. It's not sworn testimony. It was simply her representation to the court that if there's a confidential informant involved, that at some later point it might be possible to unseal the warrant. I think that was at the motion to unseal hearing that she made that comment. And so we really have no record to act on here. And that goes back to what the real deprivation of due process was for Mr. House. Is that-
Counsel, I have a question about the state stipulation in the plea agreement. Now, is there a written plea agreement? I couldn't find a written plea agreement in this case.
The record only has I'm sorry, I'm forgetting the title. It's not a plea agreement, it's the notice or the.
Right. So we don't have anything
possible
written.
Sentencing recommendation.
That's it,
Thank
yeah,
you.
you're right. We don't have anything that indicates what the state stipulated to other than the transcript.
We have the transcript.
Okay, so I see there's 3 motions and I guess maybe, well, rulings that could be at issue. 1, the motion to unseal, which was denied. 2, the motion to suppress, which I contend was never addressed. And 3, the state's motion to strike the motion to seal, which was granted. So.
It was a motion to strike the motion to suppress.
I'm sorry.
Yes.
You're right, and I'm wrong. And that was granted. So which of those are reserved for review? Which of those did they stipulate to?
According to the transcript, the state's stipulation was that if the motion to suppress were granted, it would be dispositive because they had no other evidence.
But they also
against the
specifically
defendant.
said, but that's, we don't stipulate to that this particular motion met that standard because, and that's why we moved to strike it or something like that.
Right,
So
because
what-
the state prevented the defense from having adequate grounds for the motion and then turned around and said, well, the defense doesn't have adequate grounds.
No,
for the
I
motion.
agree with you, but
So.
I'm having trouble seeing exactly what the state stipulated to. It seems to me they stipulated to the motion to strike the suppression as opposed to the suppression itself. They did say, well, if the suppression had been granted, then it would have been dispositive. But the suppression wasn't denied.
Correct, it was
It
simply
was
stricken.
stricken.
I
So-
think
so-
what the state stipulated to, in addition to that, Your Honor, is that the state had no other basis for going forward other than the fruits of that search.
But of course, we review orders of the trial court, and the order that the trial court actually made was to strike.
Correct.
And
And that-
if the trial court was wrong, then the remedy would be to reinstate the motion to suppress. That's not dispositive, is it?
In this situation, it's potentially dispositive, Your Honor. Can I say based on the record that it is dispositive? No, because the defense couldn't create that record below. And I would argue that the nature of the rights at stake, and I know I'm into my time, but I think this is important, is why the recent Hicks decision would not control the finding of dispositivity here, because the nature of the rights that were at stake in Hicks were so different. Here you have somebody who from the very first day of the legal proceedings against him was prevented from seeing the evidence against him. That's a deprivation of constitutional magnitude. It's not a simple post-trial or post-hearing change in statutory law, and there's no argument about retroactivity here. It's absolutely clear that from day one, Mr. House was not permitted to see anything at all in the probable cause affidavit. And I think that situation and the nature of the constitutional rights at stake distinguish this and would allow the court to send this case back to allow those rights to be pursued in the trial court below. At the same time, perhaps clarifying for the trial court that it in fact had a responsibility to do more than defer to the original officer's representation that the warrant needed to be sealed. And if I could just reserve the remainder of my time. Thank you.
And I'll give you a couple more minutes. So
Thank you, Your Honor.
add 2 minutes to both sides, please.
May it please the court, Damaris Reynolds with the Office of the Attorney General, representing the state of Florida in this case. It is the state's position that this court should affirm the order striking the motion to suppress. As this court has observed, it was properly stricken. It did not present adequate grounds.
Well, would you agree, though, that the trial court violated Rule 3.220B2 on discovery, which says if the court determines in camera that any police investigative report contains sensitive information, the report may prohibit or partially restrict the disclosure.
No, sir, Your Honor, the state submits that we didn't get to that point, because what
So the
happened
trial
here-
judge had no obligation to conduct an in-camera review?
I don't think, we don't get to that point because this was a sealed document. It was presumed to be properly sealed. And so the defense filed a motion, they carry the burden, they had to show good cause for unsealing it, and that did not happen. They didn't
Well,
present
how
any
can you
evidence
how can you show
whatsoever.
good cause, though, if you've never seen it? I mean, there's a due process issue here. Would you agree with that? That there's some due process right, Fourth Amendment warrants and those kind of things?
Yes, sir, absolutely, but there's no absolute right. They didn't show good cause. They didn't allege any sort of judicial misconduct.
But you've got a right. I take an issue with your argument because you're saying that the state, under your argument, would have the right to seal anything supporting any warrant unless a party can show good cause not to have that sealed.
Well, that's not what the state was suggesting in this case. The state was suggesting that it needed to be sealed to protect the confidential informant and to protect an ongoing criminal investigation.
But
That's
how
what
did
was
the
alleged.
ASA or the judge know or even test the truth of that?
Okay, so, well, the original judge tested the truth of that. The original judge found PC based on the affidavit. Judge Miller, based on the affidavit of investigator Harris, Bruce Harris.
But again, judges sometimes make errors.
Absolutely.
I've signed probably 1,000 warrants back in my trial judge days. And I bet there were a couple there that the PC was lacking or a little shaky in retrospect. And the parties should have had an opportunity to challenge that PC, right?
Absolutely, and they
But
had
how do
an
they challenge the
opportunity.
PC if they can't see what the affidavit supporting
Well,
that
the
is?
motion to unseal was inadequate, okay? There was no good cause alleged, no judicial misconduct, no evidence, no allegation
again,
that the officer had perjured himself.
How do you allege any of those things if you don't know what it's based on? What if the affidavit said, Judge Miller, hopefully not, but say a judge in general, some judge has a stack of warrants, swearing people, signing in, and just misses it, and the warrant says, I heard he was dealing drugs. Okay, good enough, sign it next. I doubt Judge Miller would do that. But say your hypothetical judge signs a warrant totally lacking in PC. How can a party challenge that if they don't see the affidavit?
Well, the presumption in the law is that that did not happen. The presumption is not that it did happen. The presumption is that it did that it
But
did
you're
not
basically
happen.
creating an irrebuttable presumption then. The party can't see the affidavit to challenge the presumption that you
Well,
raised.
sometimes what they should have done is they should have called the officer who signed the affidavit to the stand or deposed him. And they could have asked him, they could have potentially elicited more information from that officer than what was contained in the affidavit. They could have asked, was there a CI involved? How long have you known the CI? Has the CI been reliable in the past? Has the CI been unreliable? How many times have,
But probable cause has to be based on what's in the affidavit, not what the officer may know extraneous to the affidavit.
well,
Correct.
the officer can testify to what his PC was without revealing the CI's information, can testify to what the PC was for the affidavit. That's the point I'm trying to make here.
But I think Judge Roberts' point is if, say there was an affidavit and we had the affidavit and somebody was challenging probable cause in a warrant case, the state couldn't bring the officer in and say, officer, tell us everything you know that supports this affidavit. You've got to look to the four corners of the affidavit and the search warrant to see if it's supportable, right? You don't get into the extraneous stuff.
Well, okay, so at deposition, they could have gotten into the extraneous stuff. I was suggesting they could have deposed the officer or they could have put him on the stand at the motion hearing. They didn't put the officer on the stand. They could have found out what his basis was for the PC if they hit a brick wall. If they hit a brick wall and the officer said, nope, there was no CI and I can't give you any more information because, it'll compromise an ongoing criminal investigation. At that point, then the defense could have told the judge, Your Honor, we've hit a brick wall. Not only do we need this to defend our client, but we have shown that we can't obtain this information any other way. we're asking the court to look at this in camera. And so at that point, the judge would have gone in camera, could have taken the investigator in there with the court reporter, could have questioned the investigator, could have developed a record, and made a ruling. If the ruling was in favor of the defense, great, wonderful. If the ruling was not in favor of the defense, then that record would have been preserved for appellate review. That did not happen in this case. I mean, not only were the grounds for the motion to suppress evidence inadequate, the grounds for the motion to unseal were inadequate as well. And, that's why the court did not err. The court was absolutely right. And, not only did the defense not make a good cause showing, but the state, the ASA, who's a sworn, who's an officer of the court, stated very clearly in her response opposing the unsealing, that the criteria had not been met, that the state did have a compelling
How was she able
interest.
to make that representation when she herself didn't see the affidavit?
Well, she could certainly say that she didn't intend to call the CI as a witness at the trial, that the CI was not, if that's the information she had
But
obtained from the
how could
investigator.
she represent that this affidavit should remain sealed if she didn't see the affidavit?
Well, if that's the information that she had from the investigator.
So the state has to always trust law enforcement, and every time law enforcement is never going to misrepresent or misunderstand the facts.
Well, again, there's a presumption of correctness, and nothing was done by the defense to rebut what the state was saying. The state
So
was
are you
saying,
it basically comes down to your contention is the state has a right always to seal these documents unless a defendant can show to the contrary, whereas it looks potentially arguably that the rule is the defendant has a right to these documents unless the state can show to the contrary.
Well, when we look at Chamblin and we look at Burgos, I mean, it's pretty clear that the state has a privilege of non-disclosure of persons who provide law enforcement officers with information about criminal activity, and that may be overcome when an informant's identity or the content of the informant's communication would be relevant and helpful to a specific defense. There was no specific defense that needed to be addressed. I mean, the motion to unseal doesn't even say we need this information for this specific defense. It was not pled with any particularity whatsoever. And so, when asserting that a disclosure of information is necessary to establish a specific defense, the defendant must make a preliminary showing of the colorability of the defense prior to disclosure. The defendant must not only allege a legally cognizable defense, but he or she must also support the defense with sworn evidence. That didn't happen here. What we have here is a bare allegation that the defendant could not prepare his case without disclosure. Just a bare allegation. That is what we have here.
Doesn't the defendant always have the ability to challenge the probable cause of a search warrant?
Of course. Of course. They could have challenged the probable cause in the search warrant. They didn't do what they needed to do.
How could they challenge probable cause of the search warrant without the probable cause affidavit?
They could have gotten the probable cause affidavit if they had shown good cause for its unsealing. They did not show good cause for its unsealing. And again, if they had gone in there and had shown the judge that we've got good cause, we've got a necessity, and there's no other way for us to get this information, if they had put the officer on the investigator who signed it on the stand and they had hit a brick wall, they could have asked the judge to review it in camera and make a determination. That did not happen in this case. And then, as Judge Winokur was pointing out, their motion to unseal the affidavit is denied because it's insufficient, and then they don't file an extraordinary writ. They don't contest it. And, the idea that, well, the court said we were going to move on, sounds a bit silly to me. I mean, as an attorney, you tell the court, well, with all due respect, before we move on, we're going to be filing an interlocutory appeal. We're going to be asking the DCA to look at this,
So are you suggesting it was ineffective assistance of trial counsel apparent from the face of the record then?
No, I wonder if it was part of their strategy to get the issue before this court, to be general and to be vague and to, basically say, make this circular argument that, well, we can't challenge it because we don't have it. Well, I mean, that would, totally obliterate the whole idea of sealing documents. If all you have to do is come in and say, well, I need it unsealed, I mean, that's not
Because
what
they
the-
have a right to access the warrant that was used to search their otherwise secure persons, places, and effects.
Right, but they didn't specify any specific defense. I mean, all they made was this like general statement, and pursuant again to Chamblin and Burgos, that's not sufficient.
Let me suggest a better argument for you. I think your better argument is that a plea was entered here, and therefore we can't review any error of the trial court. If that was your argument, how would you respond to that?
That a plea was entered and therefore the court couldn't.
Right, that this issue is not preserved for our review because he entered a plea. Whereas had this been on an appeal from a trial, conceivably we'd be able to review this.
Well, I think that, okay, I guess I would rephrase that. So, I mean, it's not preserved on appeal, right, it's not appealable because these were not dispositive motions. I mean, these orders were not dispositive. Okay, so a motion denying an order to unseal is not dispositive. A motion an order striking a motion to suppress is not dispositive. So the remedy here is not discharge. The remedy here, would be to remand for further proceedings, and the defendant could move to withdraw his plea.
Well, didn't they actually stipulate to dispositivity?
So the exact language of the ASA was, if there was a motion to suppress that was granted, suppressing all of the evidence in the case, yes, that would be dispositive. I wasn't willing to stipulate that this exact motion was dispositive because I don't know what the basis of the grounds were for. And that's why we asked for it to be stricken. But the state will agree, if the drugs and evidence were suppressed, it would be dispositive. So, in other words...
Actually, it is dispositive, not it would be dispositive.
It is
Less than
dispositive. Okay, it is dispositive. So,
It is dispositive.
Okay, so the state agreed if the drugs and the evidence were suppressed, it's dispositive. But before you get to that, the state says it's not willing to stipulate that the exact motion was dispositive because it doesn't state adequate grounds.
Having read this transcript, it does seem like the court and the defense, at least, despite regardless of what the state may have thought or not thought, believed that this plea was being entered on the condition that these issues were appealable, were proper for appeal. Unfortunately, because I think I agree with you that they're not necessarily dispositive on their own, at least a couple of them are, the striking and the unsealing, that the state has to stipulate. And if the state stipulates to it, then it's appealable. And that's what they thought. That's what the defense thought. That's what the court thought.
Well,
And we don't have a written plea agreement, which is why I complained to appellant's counsel about that. But that seems to affect your side just as much. We have nothing to do but, parse the words in a transcript to determine what they stipulated to.
well, I would submit that even if the state had stipulated that this particular motion was dispositive, I mean, that would not make it actually dispositive.
That's
Doesn't
Churchill.
matter. Right. The state can
That's
stipulate to
State
a
versus Churchill.
non-dispositive motion.
Okay.
Florida Supreme Court.
Well, again, the
If the
remedy...
state stipulates it's dispositive even if it's not. Right?
Okay, a motion to strike,
No, if the state stipulates that something is dispositive, even if it is not factually dispositive, on review, it is dispositive,
but in
correct?
this particular case, we're talking about a motion to
No,
strike
what
in order to
Judge
strike a
Winniker's
motion.
trying to get to is whether the state stipulated or not.
Well, the
Looking
state's-
at this language, did the state stipulate the dispositiveness of any of these motions?
Not to this particular motion, I think that's clear. I mean, the state specifically said, if there was a motion to suppress that was granted, suppressing all the evidence in this case, yes, that would be dispositive. I wasn't willing to stipulate that this exact motion was dispositive because I don't know what the basis of the grounds were for.
So it seems to me that the trial court at the time thought that it was going to be dispositive, and the defense at the time thought it was going to be dispositive. Does that make any difference?
Well, the state clarified its position. So, obviously not everyone was on the same page. I mean, the state made it pretty clear, what his position was. I wasn't willing to stipulate that this exact motion was dispositive because I don't know what the basis of the grounds were for. I mean, that's that was the whole reason that they moved to strike it, because it was legally insufficient. And you know, the court did not err in determining it to be legally insufficient and striking it. So, you know, for that reason, we would ask this court to affirm the ruling.
But before you sit down, can I ask you, would you agree this affidavit is not part of the trial court record and there's no way for us to review it for harmless error?
That seems to be the case.
Thank you.
Thank you.
Your Honors, I just want to return briefly to the idea that documents are presumed to be properly sealed once they're sealed. We can't agree to that in this case because there is a right, a due process right.
That's a civil rule, right? If I
That's
go,
correct.
If I'm a powerful state senator and I go get my divorce sealed and I don't want the papers digging around in that, there's a presumption that remains sealed, but even that presumption can be overcome.
That can be overcome, and in fact, I think there's law that the court can't seal public records just because the parties don't want them to become public. There has to be some kind of showing of need before the records could be sealed. But of course, embarrassment or protection of some party named in the records could be a reason for sealing them. But here, we're not in that situation. We're in the situation of a defendant with due process rights, a discovery rule that gives access to the documents connected to a warrant as a matter of right. And so the issue is not that the defense had to overcome something to get that warrant. The issue is that the state had to make a showing justifying non-disclosure. And we never got to the point of what
And
showing...
just to repeat what I was discussing with the State's Counsel, there was a motion to unseal. That motion was denied. We went through very, very carefully exactly what was stipulated to.
Yes, Your
I
Honor.
see nothing about stipulating to the denial of the motion to unseal.
I believe you're correct, Your Honor. The stipulation...
Then that's not an issue at all.
It's not stipulated to. The trial judge clearly told the defendant before he entered his plea, your motions, plural, are wrapped up. She even referred
Does
to
that
them as
matter?
sort
I
of
mean,
circular.
if it's not stipulated to, it must be dispositive.
I think the trial judge thought at that point that they were dispositive. But I have to agree, Your Honor, based on the record, the state did not formally stipulate to the motion to strike or to the result of the motion to unseal, the result of the motion to unseal.
But so if we think there was some error by the trial court, how do we resolve that? Is there a resolution that benefits your client other than to say we can't address it and we warn future trial courts that they need to unseal these things?
Your Honor, I think if the court is not simply going to discharge Mr. House, which the court seems uninclined to do, the remedy could be something along the lines of another situation where due process is denied, which is when somebody's sent to trial when they're incompetent, that the case could be remanded for the limited purpose of holding the hearing that should have taken place when the defense first properly raised the issue that it was not given access to the probable cause affidavit. And at that point, if the probable cause is found to be insufficient, the motion to suppress can be considered. And if the probable cause is found to be sufficient, then the judgment against the defendant would stand. But that would address the due process issue. If the court has no further questions, thank you, Your Honors.
Thank you both for your argument. We are adjourned.
All rise.